Hi, everyone. Thank you for being here. I am so glad that you are here with me today. My name is Heather Reed. I use she, her pronouns. And for those that are using accessibility technology, I'm a 60-year-old white female, and I've got ash colored hair, red glasses, and I'm wearing a black top today. And if you are really astute, you'll notice that I'm in a new office location that is not quite fully set up. So, as a reminder for every episode of Event Contracts Exposed, I am not a lawyer, and nothing that we discuss here should be considered legal advice. This is all about education, insights, and practical strategies coming from me as a seasoned professional planner. Today's topic is a planner's guide to rights and remedies. And as with everything that we talk about in this LinkedIn Live, this is related to event contracts. We are going to begin our discussion today with basic definitions of both rights and remedies. So for both Canadians and Americans, I think personally, we are most likely familiar with the right to life and liberty, to freedom of opinion and expression, the right to work and education. In event contracts, both entities to the event contract, the client, which is the entity hosting the event, and the supplier partner, who is the entity providing a service or a product, they are also entitled and protected by rights. So rights in law represent an entitlement to something. A right refers to a power, a privilege, some may think of it as a demand or a claim that is held by one entity that typically imposes a corresponding duty on the other entity. So a right is something that is imposed on the other party to perform or to provide, whether it's a service or a product. The remedy, on the other hand, is what happens when an entity does not receive their right, either in full or in part. So a remedy is the defined recourse that is available to the entity when the other entity hasn't fulfilled their terms in the contract. So remedies are designed to provide a solution or compensation for the injured entity when the contract terms are not fulfilled. The primary goal of remedies is to restore the injured entity to the position they would have been in had the contract been honored as intended. So let me repeat that one because it's a really important principle to understand. Remedies, the primary goal of remedies is to restore the injured entity to the position they would have been in had the contract been honored as intended. So let's stop using the words entity and let's change to client and supplier partner. I come from the client side. I've only ever been a planner. I've never worked on the supplier partner side. So I'm going to refer to the client as the group hosting the event. And then the supplier partners are those that are providing services or products. So it could be anything from our venues to our AV companies, to caterers, to speakers, whatever the case might be, providing a product or a service. So in this case, if we're using the words client and supplier partner, we might be hearing things like the client's right to service ABC has been breached, and the supplier partner needs to remedy the situation for the client. Or the supplier partner's right to monetary amount ABC has been breached, and the client needs to remedy the situation for the supplier partner. So simply put, rights and remedies in event contracts ensure accountability from one party to the other. They are contractual safeguards, and in some cases they are legal safeguards, but they are practical safeguards for both clients and supplier partners. Now, in my world of 30 years of experience of reviewing hundreds upon hundreds of event contracts, particularly hotels, resorts, conference centers, and convention centers, what I know to be true is that the legal entities paid to create the supplier partners' draft contracts have typically protected the rights of and the remedies owed to the supplier partner. Quite often we will get draft contracts that are very clear on what happens when the client or the group hosting the event fails to meet the contractual terms of the contract. So we think about a supplier partner's rights. They are owed payment. They have the right to payment from the client. They have the right to charge interest on late payments from the client. They have the right to terminate the contract for cause if the client breaches the terms of the contract. And then quite often in those contracts, we'll also find that the legal counsel for the supplier partner has clearly defined what the remedies will be. So you'll see terms like liquidated damages, retention of deposits, the ability to relocate meeting space, the ability to modify staff assignments, the right to suspend services. So all the way through an event contract, quite often we will see what happens when the client does not fulfill their obligations. What are the remedies owed to the supplier partner? But what is not always so equally presented are the rights of and the remedies to the client. And that's what we're going to cover in the remainder of our time together today. So what kind of rights should a client expect to negotiate into their supplier partners' event contracts? Well, I have 5 that I want to discuss today. And I'm thinking that 2 or 3 of them should be on every planner's radar. And then I hope there's a couple that might cause you pause and go, oh, hadn't really considered that one before. So I want to discuss to you 1, performance rights, 2, cancellation rights, 3, audit and information rights, 4, force majeure and termination rights, and 5, intellectual property and usage rights. So we're going to talk about each one of these individually, and we're going to talk about all of the rights, and then we will address remedies towards the end of our time together. So performance rights. The client is entitled to the contractual assurance that the contracted deliverables will be provided as contracted. So it might be a number of hotels, sleeping rooms will be available as per the room block that's been contracted. It may be that the AV setup will be rehearsal ready on time and exactly as contracted. A performance may be that the entree at the gala dinner will be served hot and on time using trained staff. It may be that the pre-function spaces will be cleaned as per venue standards. So the possibilities of where performance may come into play are endless when you have an event. So if the client is contracting for services or products that are dependent upon or affected by the performance by the supplier partner, the client needs to be particularly attentive to negotiating language to measure that performance. So we might see terms like reasonable efforts. In some cases, we might even see best efforts, which really should be clearly defined. What does reasonable effort or best effort actually mean? What steps or items does reasonable efforts include? What steps or items does best efforts include? And then looking at it from a client's perspective, are these steps or items actually sufficient to meet the client's expectations? Should there be additional steps or additional items specifically negotiated into the contract to remove any ambiguity about the client's expectations? The client also needs to be particularly attentive to negotiating exact language that sets specific performance expectations. And I'm going to give you a few examples. So, specific start times and end times of event functions, specific start times and end times of meal times, specific service staff to attendee ratios that are expected by the client, specialized training minimums required of staff, the bartender to attendee ratios, the duration of meal times before there are additional labor charges added on, the minimum number of devices handled by internet capabilities, the minimum Wi-Fi upload and download speeds, even granular as the number of banquet tables and chairs being contracted for your event. So you can see how specific those are. They don't leave room for ambiguity. You know exactly what you're contracting for, and the the supplier partner is also well aware of what is being contracted and the expectations. So to me, the more exact a contract is about client expectations, the more measurable the supplier partner's performance can be. So to sum up performance rights, the client is entitled to the assurance in the contract that the contracted deliverables will be provided and or performed as contracted. So that's the first right. Second, this one should be on every planner's radar and probably is for a very, very specific reason. Cancellation rights. So the client is entitled to the assurance that it has the ability to cancel the supplier partner contract in two scenarios. One, the client wants to be able to cancel the supplier contract for their own business reasons. And let me tell you, probably every planner on the planet knows that 99.9% of the time, cancellation terms are included in a supplier partner's draft contract. They are protecting their right to collect revenues in the case of cancellation by the client. The second scenario is not so common. The client wants to be able to cancel the supplier partner contract in the case where the supplier partner breaches the terms of the contract and the client needs to cancel the contract. This is rarely included in a supplier partner's draft contract template. In both cases, the client wants to have language that identifies under what conditions the client can walk away from the supplier contract, with the expectations of remedies being associated with walking away. So, in two situations, cancellation rights need to play out. One, always there, the cancellation by the client for their own business needs. And two, the client wants to be able to cancel because of the supplier partner's breach of contract. So in the case of cancellation, because the client wants to cancel, we know that event contracts most often clearly identify the remedies that the supplier partner is owed. And those remedies are primarily in the form of financial damages. And we typically see them called cancellation fees. And those cancellation fees are typically based on a formula or a calculation based on the client's contractual revenue commitments. Now, in the case of cancellation, because the supplier partner has breached the terms of the contract, clients will most likely need to negotiate language into the contract. In this case, the client will want to explore under what potential situations the supplier partner may breach the terms of the contract and why the client might need to cancel the contract because of that breach. So a few ideas to think about why a client might want to cancel the contract because of a supplier partner's breach of the terms of the contract. Well, I believe there's 4 of them here. 1, the hotel is unable to provide the full contracted room block because they decided to undergo some renovations to some sleeping rooms. So it may not be wise or able to host the event there from the client's perspective. 2, the resort is unwilling to offer the contracted meeting space because a more lucrative piece of business wanted exclusivity to the function space. So a large part of that client's event has become more impractical, and so they may consider that a breach of terms by the supplier partner and want to cancel the contract. Number 3 that I've thought of, a convention center has booked a client's identified and direct competitor in adjacent meeting space over the same dates. That may be unviable for the client, and it's a breach of the contract that the client negotiated, and therefore cancellation comes into play. And 4th, the hotel's published star or diamond rating status has significantly fallen after the contract has been signed. So to sum up cancellation rights, the client is entitled to the contractual ability to cancel the supplier partner's event contract in 2 scenarios. 1 we're very familiar with, which is because the client wants to for business reasons. And 2nd, because the supplier partner has breached the terms of the contract. Our 3rd kind of event contract rights for the client that we're going to talk about today is audit and information rights. And this one I think will be a little bit new. So here the client wants to ensure that the supplier partner's contract protects the client's rights to request and inspect documentation that is used for billing purposes. So here the client may want to proactively negotiate that the client has access to pre-event reporting, including sleeping rooms blocked, sleeping rooms reserved, the net inventory of the property, and the total sleeping rooms left in the venue. They can measure their performance to date. The client may want to request the right to have post-event reporting, which may include sleeping rooms occupied per night. It may include the percentage of singles versus doubles. It may report sleeping room revenue, the number of complimentary rooms awarded to the client. It could have things like the number of dishonored reservations, attendee cancellations of their sleeping rooms. So the documentation allows the client to preview their performance prior to billing. Number 3 that they may want to request is any documentation required to provide detailed data to the client that support cancellation or attrition claims. And I know I've encountered that with planners where they're not being given reports that demonstrate that they are in fact in a position of attrition. So negotiating the right to that documentation in advance is crucial. Number 4, the results of an audit by the supplier partner to review the sleeping rooms occupied by the client's attendees who booked outside the sleeping room. An audit is a proactive clause to negotiate into a contract. What about the opportunity to be present on site for the monitoring of recording liquor consumption, the counting of on-consumption items, the counting of plates or utensil wraps used during meal service, those sorts of things. And then finally, what about negotiating the right to have the opportunity to review the event charges on a daily basis to confirm accuracy and completeness for event-related billing? So the client's desire to protect against overcharges or inaccurate billing needs to be demonstrated through negotiated rights to have access to event-related documentation that leads to the billing of the client. This includes negotiating audit procedures, requesting on-site reporting, pre-event and post-event reports, and on-site monitoring. The 4th topic for clients' contract rights is termination rights. And this one, as we have learned in the most dynamic and unpredictable way, the client requires the rights to terminate their event contracts due to unanticipated circumstances beyond the control of the client. So these might be things like natural disasters, epidemics or pandemics, strikes by employees of the supplier partner, disruption or curtailment of transportation to and from the event by the client's attendees. And you know that the list of possibilities could be a webinar all in of itself. But in this case, the client needs to terminate the supplier partner's event contract. Well, then the client needs to ensure that that right is actually protected. It is common for draft contracts to protect both the supplier partner and the client, but it is not always there. So it is imperative that the client reviews the appropriate language, knowing that it may very well not be protected in the draft language. So I know that there's been so many industry webinars and articles to learn how to protect the client's rights in the case of termination. And then finally, we look at the client may need to protect their intellectual property and the usage of that intellectual property. Clients of all kinds, not-for-profits, association, particularly corporate, they may need to ensure that they retain control over any recordings, photos taken, event branding that may be taken and captured by the supplier partner. Protecting the client's intellectual properties, such as the use of a logo, branding, photos, recordings, from an unauthorized use by the supplier partner may be necessary. And if so, it is on the client to include that exclusion or the terms around the use of intellectual property in the event contract. So this protection, worked out in contract language ahead of the event, ensures both mutual clarity around who owns recordings, who owns photos, who can use logos where and when, and who can repurpose materials. So we've just discussed 5 rights that clients may want to ensure are protected in their supplier partners' event contracts. Rights represent an entitlement to something. Remedies, on the other hand, are what happen when an entity does not receive or partially receives their negotiated rights. Remedies are the defined recourse available to an entity when the other entity breaches the contract. And they're designed to provide a solution or compensation for the entity that was harmed. So we're restoring the harmed entity to where it would have been if the contract had been fully and properly performed. So let's talk about the remedies, specifically remedies for clients when the supplier partner fails to deliver or breaches a term of the contract. So typically there are two common remedies available. One, monetary remedies, and two, non-monetary remedies. So let's explore first monetary remedies. These may take the form of refunds to the client for undelivered services or products. Monetary remedies may take the form of credits for the client to use towards future events. So those would be monetary credits to be used in the future. Monetary remedies may take the form of a percentage discount on the client's master account to represent the underperformance by the supplier partner. So we often see monetary remedies, but we need to protect monetary remedies for the client when the supplier partner does not perform as contracted. And the second common remedy is what we've called non-monetary remedies. So these are things where they've improved the situation or they've offered an alternative to a situation. They're not necessarily an exchange of actual money, but they are an exchange in compensation of a situation. So think about upgrading of sleeping rooms when the contracted types are not available. We could think about upgrading menu selections when contracted menu items are no longer available. It may be redoing a stage setup at no cost when the initial install was not done to specifications. It could be complimentary nutrition is included on a liquid beverage only break. It could be additional complimentary concessions provided to all of the attendees. It could be upgraded meeting space with waived Wi-Fi fees to compensate for the unavailability of meeting space. And again, the list of remedies that are non-monetary can be as creative and as unique to the client as the possible situations. But what I want you to know is that remedies should be specifically thought out as much as possible before contract negotiations if the client wishes to contractually bind the supplier partner to those forms of compensation. Negotiated remedies for the client from the supplier partner need to be tailored and written directly into the contract. There needs to be clear outcomes to prevent disputes and to remove ambiguity. Now, there are also legal remedies that are provided for under general contract law, but pursuing those, such as direct, indirect, consequential financial damages, securing those and proving those is often costly and time-consuming, and in my opinion, best avoided whenever possible. So defining monetary and non-monetary remedies upfront saves time, money, reputation. It avoids reliance on courts to interpret vague terms, and it builds mutual trust between the client and the supplier partner. So we are at the top of the hour. I hope today's discussion on a client's guide to rights and remedies has been insightful. I would ask that you follow Plan or Protect on LinkedIn for notice of future episodes, and in particular for next month's episode happening on Wednesday, September 17th at 2:30 p.m. Eastern. And I will close this broadcast with Always remember, a well-negotiated event contract isn't just a document. It is your power, your protection, and your peace of mind. Bye for now, folks.
Okay.